there is a liberal bias, all the things, all that.
Fascinating issues surrounding surveillance, intelligence, new technologies, that if we were to cover them all with panels of the sort you just saw, this would be a conference that would last approximately 3 weeks. And because even I have limits to my capacity to focus on these issues for that long, we have, for the last couple of years, been inviting scholars and activists to present shorter flash talks that focus very tightly on a single subject and present work or analysis that they've been doing in a way that allows us, I think, to get a sense of the range of hard questions we face as citizens and policymakers. So our morning block of flash talks covers issues from facial recognition to social media surveillance to the global war on encryption on various fronts. So I'll just very quickly introduce the speakers. If you want fuller biographies, look to the conference website on cato.org. You will find, in addition to the agenda, links on the speakers' names for more extensive biographies. We're going to begin with an analysis of recently passed legislation in Australia that seeks to mandate law enforcement access to encrypted software, encrypted messaging tools. It's, in a sense, it's sort of a first of its kind, but could be a model for emulation elsewhere. For that, I want to invite from New America, Sharon Bradford Franklin.
Thank you. I'm Sharon Bradford Franklin with New America's Open Technology Institute. And if you had told me a year ago that I would be here today talking to you about Australia, I would have actually thought you were joking. But I'm really glad to have the opportunity to speak with you today about the law just passed earlier this month in Australia and how this could actually allow the United States to look down under for an encryption backdoor. All right, got to get the clicker working. Here we go. So, for those of you who may not actually be already familiar with the long-standing encryption debate, this is a battle that pits security against security. For years, the US Justice Department and the Federal Bureau of Investigation have been arguing that they're, quote, going dark due to the increasing use of encryption. They've complained that they can no longer access many electronic communications even when they have a valid court order. Many tech companies now have encryption by default and in their products and services, and they simply do not have access to their users' encrypted communications. The Justice Department and FBI want to require that tech companies guarantee that government has exceptional access, or what they now have started calling the use of so-called responsible encryption, so that they will always be able to access even encrypted messages. Otherwise, they say, they are hampered in their ability to keep Americans safe from terrorists and other criminals. But security researchers, tech companies, and privacy advocates have pointed out that this would amount to an encryption backdoor that could be exploited by others. There is no way to guarantee that only the US government would be able to use any such mechanism. Rather, this amounts to deliberately building vulnerabilities into products and services, and undermining device security for all would harm everyone's privacy and cybersecurity. And it would create new threats that we will all be victims of criminal activity. In addition, as we explored in a half-day forum that OTI hosted last month, encryption protects economic security and the personal safety and freedom of journalists and individuals in vulnerable communities, including victims of domestic violence. This debate, which has been going on for years in the United States, has now gone global, with a quick flare-up down under in Australia. This past August, the Australian government released what they called an exposure draft of its Telecommunications and Other Legislation Amendment, or Assistance and Access Bill 2018. Unlike the US Congress, which takes months and months, or more likely years, before it passes anything, the Australian Parliament managed to wrap up its consideration of this bill in a mere 4 months. Following a public comment period on the exposure draft, a slightly modified version of the bill was introduced in Parliament and referred to the Parliamentary Joint Committee on Intelligence and Security, or PJCIS, which opened a new public comment period. My organization, the Open Technology Institute, organized an international coalition of civil society organizations, tech companies, and trade associations, and we filed 3 rounds of public comments on the bill, outlining our concerns, which I'll describe in just a moment. The committee held a series of hearings, and then, just at the beginning of just last week, the PJCIS issued a report recommending passage of the bill with certain amendments incorporated. Early in the morning, just last Thursday, December 6th, the Parliament released an updated version of the bill, including 173 amendments that no one had ever seen before. But by the end of the day, the Australian Parliament had passed the bill into law. So what does the Australian law actually do? As one Australian commenter put it, quote, "The combined stupidity and cowardice of the coalition and Labor now means that any IT product, hardware or software, made in Australia will be automatically too risky to use for anyone concerned about cybersecurity." So we're focusing here on Schedule 1 of the Australian law, which is the one that is designed to undermine the safeguards of encryption. There are also, folks should be aware, other sections of the law that create additional privacy threats and increased powers of government hacking, but we're focusing on Schedule 1, which relates to encryption. Now, the law includes what appears to be an encouraging statement that purports to prohibit the government from demanding the creation of encryption backdoors. And I have it up here on the slide here. Section 317ZG says that the government may not request or require communications providers, quote, "to implement or build a systemic weakness or systemic vulnerability," and also that the government must not prevent a communications provider from rectifying a systemic weakness or systemic vulnerability. However, the law grants unprecedented new authorities to the Australian government that undermine this promise. Specifically, the law creates 3 new and powerful tools for the Australian government: technical assistance requests, or TARs, technical assistance notices, or TANs, and technical capability notices, or TCNs. The requests are supposed to be voluntary, whereas the notices are mandatory, and the difference between the TANs and the TCNs depends on which government official is authorized to issue the notice. All of these authorities authorize the Australian government to request or demand any, quote, "listed act or thing." Now, that's a long list in the bill, and it includes things like removing one or more forms of electronic protection that are or were applied by or on behalf of the provider. And it also includes modifying or facilitating the modification of any of the characteristics of a service provided by the designated communications provider. In short, these are powers to demand that tech companies weaken the security features of their products. For example, the Australian government could now make the same request to Apple that the FBI made in the 2015 San Bernardino shooter case, that they build a new operating system to circumvent iPhone security features. As Apple explained in the San Bernardino case, building the requested software tool would have made that technique widely available, thereby threatening the cybersecurity of other users. As we know, in the lawsuit here in the US, the United States government argued that under the somewhat obscure All Writs Act, which dates back to 1789, they were permitted to make this demand of Apple. But Apple, supported by other tech companies and privacy advocates, argued that this demand was unconstitutional. The Justice Department ultimately withdrew its demand because the court could resolve, and before the court could resolve the legal question, because the FBI was able to pay the outside vendor to hack into the phone. But in Australia, they now have a specific authority to make these kinds of demands. Another worrisome scenario is that Australia may seek to use its TCN authority in the same way that the United Kingdom is looking to use its powers. Just last month, Ian Levy and Crispin Robinson of the UK's GCHQ, which is essentially the UK's NSA, put out a proposal in Lawfare. Under this proposal, tech companies would be asked or required to add GCHQ as a silent participant in end-to-end encrypted chats, and the tech company would suppress the notification to the user. They argue that, quote, you don't even have to touch the encryption to add GCHQ as a ghost user inside the encrypted chat.